Earlier this afternoon, I want to share news of a genuine legal victory, one that arrived quietly amid the usual chaos of competing headlines and was largely overshadowed by broader political theater. Still, it shouldn't be dismissed. What took place at the Supreme Court at approximately 2:17 p.m. Eastern marks the first time in recent memory that the nation's highest judicial body has directly rejected an emergency appeal from Donald Trump targeting a member of the press. Legal experts who closely track executive power cases and constitutional scholars who have spent years studying First Amendment protections both describe this moment as unprecedented. The former president sought to halt legal proceedings against him involving MSNBC host Rachel Maddow, exposing himself to a courtroom confrontation he desperately wanted to avoid. At a glance, this could be mistaken for routine appellate procedure, another technical motion in an endless string of legal battles. But this was never about procedural technicalities or scheduling conflicts. It's about whether a former president can weaponize the courts to silence critics and delay accountability. What follows will uncover the parts of this episode most people haven't seen. At a glance, this could be mistaken for just another legal skirmish in Donald Trump's ongoing war with media figures who dare to criticize him. Another attempt to intimidate journalists, another effort to manipulate the legal system for personal advantage. But this was never about one television host or one defamation case. It's about the fundamental principle that no individual, regardless of wealth or former position, stands above constitutional protections for free speech and a free press. What follows will uncover why Trump became so intent on blocking this particular trial, why the Supreme Court responded with such swift and decisive rejection, and why an institution that has frequently granted emergency stays in other high-profile cases finally decided this was the line that could not be crossed. To understand how we arrived at this moment, the sequence of events matters. Roughly 8 months ago, Rachel Maddow aired a segment examining Trump's financial entanglements with foreign entities, relying on publicly available tax documents and investigative reporting. Trump's legal team immediately filed a defamation lawsuit seeking $475 million in damages, characterizing the coverage as malicious falsehood designed to destroy his reputation. What followed went far beyond a standard defamation claim. The objective was never simply monetary compensation or correction of alleged inaccuracies. Legal observers familiar with the filing noted that embedded within the complaint were demands for injunctive relief that would effectively prevent Maddow from discussing Trump's finances on air until the case concluded. The lawsuit proposed deposing dozens of MSNBC staff members, demanding internal communications spanning 3 years, and seeking access to editorial decision-making processes that news organizations typically protect under journalistic privilege. At this point, the behavior moved beyond a defamation case and into potential First Amendment violation territory. That shift is precisely what the Supreme Court identified in today's unsigned order, culminating in the emergency motion's rejection. The Supreme Court's language, though brief in the unsigned order, was unequivocal. The ruling emphasized that emergency relief from the nation's highest court requires demonstrating irreparable harm that cannot be remedied through normal legal channels, a standard Trump's motion spectacularly failed to meet. Chief Justice John Roberts, joined by the full court in this decision, made clear that disagreement with media coverage, even coverage the petitioner characterizes as unfair or inaccurate, does not constitute the type of irreparable injury that justifies circumventing established trial procedures. The rejection is more than a procedural setback. It is a constitutional reaffirmation. It represents a clear statement that the machinery of justice cannot be manipulated to silence critics or shield public figures from accountability, which brings us to the legal community itself. For much of the past year, Trump has successfully deployed emergency motions and appellate maneuvers to delay, obstruct, and complicate numerous legal proceedings against him. Federal courts have granted stays in classified documents cases, postponed trials and fraud proceedings, and allowed extensive discovery disputes to drag on for months. So what shifted? Why did the Supreme Court at this particular moment choose to reject Trump's emergency plea without oral arguments, without extended deliberation, and with unusual speed? It had nothing to do with sudden commitment to press freedom or newfound appreciation for adversarial journalism. The real reason is institutional self-preservation. In Washington, judicial authority rests as much on public perception as on constitutional text. When lower courts granted Trump repeated delays and favorable procedural rulings throughout 2024, it sent a troubling message to legal observers that wealth, political influence, and celebrity status could indefinitely postpone accountability. When the Supreme Court received this emergency motion seeking to block a trial involving a journalist's First Amendment-protected speech, the justices recognized that granting such relief would permanently damage the court's credibility on free press issues. Former prosecutors who have handled high-profile defamation cases describe the decision as the bare minimum required to maintain judicial legitimacy. This episode marks one of the clearest signs yet that even a conservative majority Supreme Court recognizes limits to how far it will bend established precedent to accommodate Trump's legal strategies. It's among the first real indications that the court understands its reputation cannot survive unlimited deference to frivolous emergency petitions. Still, it would be reckless to underestimate the danger ahead. The cultural consequences are equally significant. Trump targeted Rachel Maddow and MSNBC because he understands a simple but powerful truth. Controlling which stories journalists can tell is a direct route to controlling public understanding of his conduct. His goal was to overwrite the legacy of investigative journalism, one built on holding power accountable, exposing corruption, and informing citizens, with a narrative rooted in grievance, victimhood, and the delegitimization of any critical coverage. The Supreme Court may have stopped this particular attempt to silence a prominent journalist, but it cannot end the larger struggle for press freedom in an era of authoritarian politics. That battle is playing out in courtrooms across Florida, where Trump allies have filed similar defamation suits against local reporters covering election administration. It's happening in state legislatures where bills are being introduced to make it easier for public figures to sue media organizations, effectively reversing decades of First Amendment protections established in New York Times versus Sullivan. The attempt to block the Maddow trial through Supreme Court intervention was merely the most visible tip of the iceberg. This is not about one defamation case or one television host. This is about whether journalism can function when every critical story triggers lawsuits seeking hundreds of millions in damages. And let this serve as a clear message to those in power. We are watching the court filings. We are watching the legislative proposals. We are watching every attempt to weaponize defamation law. We will not allow constitutional protections for free speech to be liquidated piece by piece through strategic litigation and judicial intimidation. Still, it would be reckless to underestimate the danger ahead. A former president who feels cornered by legal proceedings, embarrassed by public rejection from the Supreme Court, and facing a trial he desperately sought to avoid, is not a diminished threat. Trump has never accepted judicial losses quietly. He doesn't interpret today's Supreme Court ruling as a lawful application of established emergency motion standards. He interprets it as betrayal, as evidence of a rigged system, as justification for escalating attacks on both the judiciary and the press. The next 72 hours matter. With the Supreme Court emergency route now definitively closed, and the Maddow trial scheduled to proceed within weeks, Trump's legal and political vulnerabilities have only intensified. Pressure shapes behavior, and when conventional legal strategies fail and judicial deference dries up, attention inevitably shifts toward more desperate tactics, which brings us back to the warning about witness intimidation and jury pool contamination. As the trial date approaches, expect sharper attacks on Maddow personally, on MSNBC's parent company, and on the presiding judge. Watch for social media posts designed to prejudice potential jurors, for orchestrated harassment campaigns against court personnel, and for claims that the trial itself represents political persecution. We may also witness attempts to forum shop by filing related cases in friendlier jurisdictions, sudden appeals claiming judicial bias, or efforts to invoke executive privilege claims that have no legal foundation. Desperation doesn't retreat, it adapts. Today's Supreme Court rejection represents a clear win for the rule of law and press freedom, but it also raises the stakes. It increases Trump's motivation to find alternative methods of intimidation and obstruction. To the citizens who have felt powerless watching Trump manipulate the legal system for years, I want to speak directly. I know how easy it is to feel like the institutions designed to protect constitutional rights are faltering under the weight of endless litigation and bad faith appeals. I know the disillusionment of seeing courts grant delay after delay, while accountability seems perpetually deferred. But look at what has occurred today. Look at the scoreboard. The Supreme Court, including justices appointed by Trump himself, unanimously rejected his emergency motion and allowed a trial challenging his attempts to silence a journalist to proceed. Yes, the legal system remains imperfect and vulnerable to manipulation, but the institution still functioned when it mattered most. That should remind us that if one critical First Amendment case can be defended against executive overreach, so too can the constitutional framework itself. We cannot safeguard press freedom in one case while ignoring broader threats to journalism and accountability. Across federal and state courts, facts must guide us. Every citizen deserves transparency about those who seek power. Those judges who stood firm against this emergency motion must show the same courage when Trump inevitably returns with new appeals, new delays, new attempts to avoid facing his accusers in court. And let this serve as a clear message to those in power. We are watching the trial calendar. We are watching the procedural motions. We are watching every maneuver designed to obstruct justice. Democracy is not a spectator sport. It requires active participation, constant vigilance, and courage from every one of us. If this breakdown helped cut through the noise and explain what's truly at stake when former presidents try to weaponize courts against critics, consider subscribing. Sustaining reporting that prioritizes constitutional principles over partisan narratives is essential during moments like this. I'd like to hear how you see it. Do you believe this Supreme Court ruling represents a genuine turning point in holding Trump accountable, or is it simply a temporary setback in his broader strategy of legal obstruction? Let me know in the comments below. Thank you for watching. The trial begins soon, and I'll be tracking every development as it unfolds.